good morning, and welcome to the SA Innovation Summit TechSpert Sync Up. Very much looking forward to the session here today, where we are talking about intellectual property. This is an exciting topic for innovators because IP, or your intellectual property, is
good morning, and welcome to the
have your value being created and it being owned by you and protected by you, which is how you can then make sure you are able to get the rewards of your innovations and continue to innovate. And without further ado, I do want to bring up on stage or on air our masterclass TechSpert for today, Christine Strutt. She is a trademark and copyright attorney at Von Seidels, and they are specializing in IP work, protecting it for businesses and organizations across Africa. Here to give us the foundations and key things you need to know and think about as you are innovating. We do want to also invite you to bring in your questions in the Q&A. Very important, because this is a masterclass and a workshop where we are able to interact and engage in the Q&A section at the end of the session. So without further ado, thank you so much, Christine, for today. Looking forward to it, as I know they can also reach out in the booth that Von Seidel has. So over to you.
Thank you, Buntu, and thank you all for joining this live session. Now, I considered this topic of the masterclass, the IP primer, and I discovered that the word primer has a couple of meanings. One is, of course, to apply an undercoat or foundation of some sort for further layers. But a patent attorney will tell you that can also describe a compound that can ignite a charge or explosive, or a small pump of fuel that starts a combustion engine. Now, my aim with this IP primer is to give you both that undercoat on which you can build further layers of understanding, but hopefully it will also ignite something and get your IP engines going, so to speak. I have prepared slides that you can refer to afterwards, and just in case we run out of time, we've organized a hangout at 4 o'clock this afternoon where you can meet some of my colleagues and ask us anything intellectual property related. Please also remember to post questions. I think there's a sidebar, and to go and visit the community chat called IP Primer Q&A. So to get us started, what is intellectual property? At its core, it's simply a collective name for different legal rights pertaining to creations of the mind. Now, that phrase could possibly become outdated the more we rely on algorithms to think for us. But be it as it may, these creations come in different forms, and each form has a different bundle of these rights. Unsurprisingly, IP has become one of the most valuable business assets of the information age. And some of the most valuable companies in the world are IP-focused businesses. But it is a misconception that only large corporations need to manage intellectual property. In fact, for startups in particular, investing the time to develop an IP strategy, creating an IP portfolio, and conducting an IP risk assessment can influence your opportunities for funding, an exit, and more importantly, your survival. So let's start with patents, which is often perceived as the most commanding form of IP. Now, a patent is essentially an incentive or a reward by which the state grants the inventor a 20-year monopoly to exclusively profit or exploit their idea in exchange for putting it on a public record, which is the patent register. In doing so, they ultimately improve society by having the invention become part of the public domain. Now, to be patentable in South Africa, an invention must be new, worldwide, it has to be inventive, and it has to be useful. There are also certain types of inventions that are strictly not patentable. And there I've given you a list, but you'll notice that I've underlined computer programs, ways of presenting information, and business methods. It's important to note here that although these things are not patentable as such, they aren't completely prohibited from being part of a patentable subject matter. And also, I should mention, these are the rules for South Africa. Different rules apply in different countries. In a presentation like this, it's always fun to see what people have patented in the past. So here I've got a patent which I thought was particularly cute. It is for a pair of glasses for your chicken, and it prevents other animals from picking at its eyes. I thought it was so adorable. I might just get a chicken after seeing that. Here we have the expired patent for Lego blocks. We've got one for a toilet roll, which clearly settles the debate on which way you should hang it. This is a public transport hammock, also convenient for a home office desk, and a very strange face shield intended for sport, which I'm pretty sure never actually reached the market. But these ideas are here. And nowadays, we find ourselves here. So you're more likely to see something like this on a patent register, in addition to physical objects. This is the Google Smart Home patent that sets out how all the different elements work together, and interestingly calls the operating system a home policy manager. This was the drawing on a smart TV that's operated by gestures. And this one I found so amazing. It is a method for identifying different kinds of influences on social media. Now, a lot of talk in this community is around the cost of IP. So throughout this masterclass, I'm going to share some resources that are freely available and that you can use to see if your idea is new or whether you have something registrable. Now, this is the CIPC's free patent search tool, but you can also search for prior art on Google Patent. This is great for detecting something that has been filed in different countries. Onto registered designs, because as you know, patents can be very expensive and you have to renew them every year, and then they still require enforcement. Having said that, they can be strategically used in your business. I won't elaborate on that, but my colleague Ralph does a section after this in which he will share more about that. As I mentioned, registered designs might be more palatable for a very fresh young startup. Now, a registered design protects the way something looks, and it's generally applied to interesting shapes that are novel and unique. In South Africa, you get two types, and they generally give you protection for up to 15 years. Designs have this fixed lifespan, like a patent, and also like a patent, they have to be filed before you launch the design. In South Africa, there's a 6-month grace period for disclosing the design to the public, but not all countries have this grace period. So it is advisable to file your design application before actually releasing it into the market. Now, as an example, I've set out this comparison here because designs give you a relative form of protection. So basically, the degree to which the infringing product resembles your product must be closer in degree to which your product resembles that which was already available in the market. Sounds a bit confusing, but I think this illustration shows a fairly obvious infringement. Designs are also being used for user interfaces. So this is Apple's swipe right to unlock feature. And you can read below there that Samsung allegedly had to pay Apple $120 million in damages for launching a similar looking feature. To the right is the iPhone text bubble, which is the reason other phones aren't supposed to have little curves on their speech bubbles in chat. But it's not only Apple that uses this form of IP. Here's some more examples. We've got Microsoft's screen layout, Twitter's drafted emojis, Tinder's swipe screen, the Netflix menu, and Airbnb's booking page. If you do search for these online, don't be confused. In the US, a registered design is referred to as a design patent. So all these do protect the way these features look, not the underlying technology, which would be the subject of a patent. Designs are registered in classes, so you can search for the appropriate class on this page for free. And like patents, you can also do a free search on the Trademark View database. I find it particularly useful. I appreciate, however, that not all businesses need patents or designs, but all businesses have a brand or a trademark. Now, that's any symbol which serves to distinguish your products and services from those of others. So essentially, it is a source identifier. And for a trademark to be recognized, it must be non-descriptive and distinctive so that it cannot be confused with a competitor. In most countries, a trademark registration lasts for 10 years, and then it can be renewed indefinitely for further periods of 10 years at a time. As a general rule, the value of your trademark increases over time the more you use and promote it. Because other forms of IP have a fixed lifespan and generally depreciate over time, this can make a trademark your most valuable business and IP asset. You do receive some protection by simply using and promoting your trademark, but you can also register it, which gives you far more stronger claim to the mark. So here are a few of the earliest trademarks, with the Pilsner trademark believed to be the oldest registered mark in the world. But these days, what we associate with trademarks is visual design features, app icons, possibly even dash buttons. And there's also a rise in non-traditional trademarks that meet the following criteria of being clear, precise, easy to access, durable, and self-contained, and basically represents something that people can see as a source identifier. As an example, here are a couple of color marks. I bet you didn't know that 3M has a monopoly on light yellow for sticky notes, or that John Deere has actually registered the color combination of green and yellow. These are gesture marks or movement marks. Now, 2 of these weren't allowed. The gesture at the top for tossing salt was simply too general for a chef. And the bottom hand gesture that goes like this for turning down the volume on a smart speaker, that was thought to be too generic or too functional. So those were not allowed. But all the other marks on this page are registered trademarks, including the shape that the water sprays out of the jet ski at the top there. Close to home, we've got some pattern and shape marks as well. To the left, we've got Twitter's floating like hearts. In the middle, there's the shape of the Cape Town Stadium. And on the right is an animation for a Vodafone logo. As I mentioned, a trademark has to be distinctive, meaning it cannot resemble an earlier mark. It cannot be descriptive of your goods or services. It can't be generic, a common term, or something that's reasonably required for use or laudatory. Now, a somewhat useful interplay between designs and trademarks is the following. Let's say you have a pattern or a design feature that you think is a trademark, but your consumers don't really see it that way yet. What we suggest is that you register your design in the meantime, and when it expires in 10 or 15 years' time, by that time you should have built up quite following and educated your consumers that this is in fact not simply a design feature, but actually your trademark. When the trademark then gets registered and the design falls away, you're left with an IP right that you can renew indefinitely. Here's a great example of a design that has become a trademark. But since trademarks can't be purely functional things, just make sure that you register an aesthetic design, because a functional design might just delete your possibility of claiming that it is a fanciful trademark later on down the line. Another good example is this recognizable layout of an iPhone store. But again, it does have some functional features, and you don't want to go too far in that direction, because you can also lose some of your distinctiveness if your trademark is seen to be functional, useful, or becomes generic over time. Nowadays, with digital media, trademarks are not only your shop front, they also become an important messaging tool. But still, registration matters, as Netflix and the US government will tell you. If you want to go and search whether your trademark is available or whether it's too close to an existing mark, you can look for South African marks on this free tool on the CIPC website. You can also consider foreign databases at TMView. Trademarks are filed in classes, just like designs. So again, TMView gives you a good tool to search for the appropriate class in which you need to register your trademark. Copyright is the next form of IP I'm going to discuss. And it's great because you don't have to register it. It exists the moment that you create something tangible or digital. It is registrable in some countries, and often that's a good idea, especially if you want to do some online takedowns. It's important to know that your copyright only protects the expression, not the underlying idea of the concept. So that would be more in the realm of a patent, of course. But as you can see, copyright does have a bit of an overlap with trademarks and registered designs. The one obvious overlap is that copyright doesn't protect you against reverse engineering. So unfortunately, if something is made available legally and someone else takes apart that three-dimensional object that is manufactured through an industrial process and rebuilds it, copyright doesn't really address that problem for the originator. And in those cases, it is necessary to file a registered design. But in other cases, copyright can be a good backup if you haven't registered your logo or perhaps a jingle for your business. It can protect your patent drawings or software code. It can also even protect the fanciful parts on a design registration that you can consider to be more artistic and not manufactured by an industrial process. So copyright really does bind together a lot of forms of IP, but protects the expression of some material work. Now, the most important thing about copyright to consider is ownership. Because there's nothing registered when it comes into existence, you will need a document of some sort, either establishing or transferring ownership of copyright. And in many countries, copyright is considered to be something that belongs only to humans. until this guy came along and took his selfie. Now, sadly, there's no real decision on whether this photographer owns the copyright in his image, because Peter and the owner of the camera equipment settled this. But in the coming years, we can expect to see more questions about whether non-humans, specifically an artificial intelligence, can be considered the author of their own creative works. Another new thing to consider is what we call database rights. Now, in South Africa and Australia and the US, there's no specific separate right for a database, and it's covered by copyright. But in the EU and the UK, you do get special rights for compiling a database. Locally, the information in that database might be subject to the rules of the new POPI Act that recently has come into force and by which you'll need to comply by July 2021. In business, you'll also have many trade secrets and confidential information. Now, these can be recipes, manufacturing processes, sales method, or any of the items that I've listed below. These are typically protected through agreements and contracts, and they will relate to both your employees and independent contractors. Confidential information does have its limits, and it does not include something that either was or became public in some other way without being disclosed by one of the parties. An interesting form of IP is know-how. Each entrepreneur will appreciate that there are things in your business that you simply know how to do. And know-how protects that component in your technology or your business that is basically the how to accomplish something. Again, this is often dealt with contractually, but it can be a very valuable part of your business assets. Back to free or almost free resources. WIPO-Proof is a new digital business service that provides a date and time-stamped digital fingerprint of any file, proving its existence at a specific point in time. Now, the wonderful thing here is that you're able to purchase a token for roughly 20 Swiss francs or 350 Rand, and you submit your document or idea to a secure storage facility at WIPO, which then serves as proof that you already had this idea or document or secret at a particular point in time, and you can claim that you were the earliest person to have that idea. Now, this file is only available to you because you hold the key to access it, should you ever need to show it to anyone else. Now, this is a screenshot of your dashboard on WIPO-Proof, and there's also an image of the premium certificate that they can issue you to confirm that you have these rights. I've also loaded some benefits of using this tool, and I really like this concept and its accessibility to everyone. Lastly, we need to touch on your online presence. Now, you need to be mindful of all the IP contained in your web presence. Choosing your domain name, your social media handles, and achieving visibility is one aspect, but also consider the limiting of your liability by either hosting or curating content on your website. There's also the liability of influencers for posting certain advertisements, and you could be dealing with other people's images, their image rights even, or shared content. These might have copyright consequences. If you're outsourcing any of the development or design of your website, or even instructing a social media manager, be careful to put down the terms of those agreements in a contract. Even if it's something that you've just written up yourself, that's better than having nothing. And consider your terms of use. This is often overlooked, but having a privacy policy is now something that is obligatory in South Africa. And having good terms to your website is the only way that you can have community rules or an agreement with the users of your site that is actually contractually binding. So that is my masterclass for this morning. I hope that I've touched on some relevant topics and kind of sparked something, even if it's just a few more questions. But please feel free to send us any questions you have and to join the meetup later.
Fantastic. Thank you so much, Christine. I think very insightful, very thought-provoking for the entrepreneurs and attendees. I do want to invite you guys to put in your Q&A. And I see that there are some questions coming in. So we'll start with the first one from the attendee here, which is, how can I register my product and logo in order to prevent others from infringing it? And so what's that process, for a product or a logo, and maybe even others that you think are common, important ones to?
I just want to stop sharing the screen quickly. Maybe you can help me with that.
Well, let's, yeah. Sure, but I think in the meantime, we'll kill that. You can continue. I'll.
Great. Yay, let's have a chat. So the question is, how can I register my IP, specifically the branding or the logo? Is that correct?
Product and then also the logo.
So when you say product, as I mentioned, that could be a design, it could have trademarkable features, but I think a good place to start as a very new entrepreneur is your brand. Like I said, consider the name of your business. Having a company name is not quite sufficient for enforcement. If you want to take down an abusive or an offensive domain name, or you want to act against a counterfeit product or object to a company name, really what you need is a registered trademark. So that's the most powerful tool in terms of your branding. But also keep in mind the visual features. So app icons, logos, those are equally important in the digital age because we've all become visually inclined. And it's not only about the phonetic and the name of your business, it is also about the visual that users appreciate when they engage with you or your website. Now, trademarks are territorial, so look at your market and decide which countries you need to register in. It can be quite expensive to do foreign registrations, but at least start where your main market is. A trademark doesn't have to be registered right off the bat. So my suggestion is test the market, see where there's momentum, and then register your most crucial trademarks there. 2 tips is, even though the market is the most important, also consider registering your trademark where you manufacture and label your products, because that is something important that is considered when you export the product and when customs officials maybe consider the packaging or the labeling. And the second thing to consider is registering the trademark in foreign languages. So if you are exporting the product to an Arabic country or perhaps China, consider what the local users will be referring to when they refer to your brand. And that might be a colloquial name or a Mandarin name, and it might be more important to get that name registered rather than the English name that you've given to your business.
Very, very interesting points there. I think, even looking at the African continent and the and how markets are so spread over the place, and entrepreneurs are always looking at SADC region or East African region, and so they need to prioritize, like you're saying, and sometimes it could be a budget issue. But if someone doesn't have any IP registration, they're limited on budget, whether that's just in one region or they want to make sure that in the entire region that they're operating in, like different countries, what would you say are the most important ones to start with? Where should they prioritize?
That's such a great question, Buntu. I would suggest, again, look at your market and start there. But if you're pursuing Africa, there are two regional systems that are very useful to consider. The one is loosely referred to as UAPI, which is sort of a group of countries, many French-speaking, and you can cover at least 13 African countries through a single filing. If you're filing a patent through the UAPI region, it's even more. I think it's about 18 countries that you can cover. Now, the second regional system in Africa, the acronym is ARIPO, and that is sort of more Western countries. It's a filing tool that allows you to select certain regions, and it is more cost effective, and we can help you in all of those. We have offices in Nigeria, in Cameroon for the UAPI system, and an office in Namibia that handles your ARIPO work for you, all in addition to our Cape Town base offices. So let us know about those. The second thing I will say about considering your first countries to file in is whether the country is a common law system or whether it has a civil law system. Because often you find that common law countries are countries that basically recognize marks that have just been used without a registration. But you also then get countries that we call first to file regions. So for instance, Nigeria, if you haven't been the first to file your trademark application, it's very difficult to claim any rights of use in that trademark. And this is particularly important because Nigeria doesn't have a specific anti-counterfeiting law, and you have to rely on various other forms of IP to stop counterfeit goods. So my tips there is consider regional systems, and secondly, consider whether you can file your mark first in first to file countries, and then when you have the budget, only then cover the countries that do give you some protection while you're simply using and promoting the trademark.
Thank you so much. I think very valuable, their insights. What about within one country? If one wants to prioritize, but budget is limited, are there any common, say, types of protections that you recommend starting with and the process thereof?
I would suggest having a very nicely designed logo, because that would give you copyright in your logo, in addition to potentially trademark rights later down the line. If you want to try and self-file, many countries are affordable. At the CIPC, for example, you can load your own account. It will cost you 590 Rand per application, and I think you can get at least the name of your business registered for that budget. In terms of classes, start small, start with your primary classes. A lot of people go in and try and cover all the goods and services that the business might potentially do at some point in the future. Rather limit these costs and focus on what you do now and what you know is your core competency and your core business.
Fantastic. So related to what you want to focus on now, you then compare the different protections, probably with some advice as well. And any tips or advice, say, when a business is starting another business, or the entrepreneur is starting a new business, and they want to choose about their company name, or they're launching a product and they want to choose the name. There's a whole process, and sometimes it might be inspirational, but there's some IP related aspects of that. What are your tips in choosing, designing, and creating names for products and businesses?
Well, in addition to the slide that deals with what constitutes a trademark and what does not, I would say the best brands are brands that allude to what the business does without being completely descriptive. So for instance, if, disclaimer, I am just using these as examples. We are not involved of any of this branding. But if you took Vodacom and MTN, I think if these were new startups today, Vodacom or Vodafone would tell your new consumers a little bit about what the business does, because there is that inclination towards voice and connection and and internet and connectivity. Whereas I think MTN, being an abbreviation, that would take a bit more of an investment, a bit of a marketing campaign, just to educate your clients what the business does. So in a vacuum, if you considered the mark, would it tell the consumer enough to engage with the business and come and find what they're looking for, whilst not being completely descriptive and basically putting yourself in a position where you cannot obtain any trademark rights at any point?
Fantastic. So very much connected to what you're doing. Another thought here, another question is related to, NDAs. I think especially in tech space and digital technology, investors say they don't have time for NDAs. Some entrepreneurs say it's a waste of time. Some of them, can't go to bed at night if they don't put out an NDA. And also technology is moving so fast that they feel that they can't really protect what they're doing. From a TechSpert perspective and some of the common faults and insights you've seen, what is your suggestion around techpreneurs when they're in this conversation, and your reflection on that topic of NDAs and them being expensive and useless?
Buntu, this is a toughie. Firstly, an NDA doesn't have to be expensive. It can be a one-pager. Unfortunately, if you're seeking funding or doing a pitch and you've got that meeting with a very large corporation or an important funder, they might not be inclined to sign the NDA, and you'll still want to take the meeting. And that's unfortunately the reality of an NDA. But in more precise circumstances, that would be advisable, just to have an NDA and agree on it. I think the thing people often miss about NDAs is that some things are simply not confidential, so they wouldn't be covered by the NDA. And I touched on this in my talk, things that are already public, that you find out from a different place, not from the person disclosing it in that meeting. Things that are already in the pipeline, those are not actually covered. So just bear that in mind. And then also when you are pitching and there is a part of your business that is absolutely crucial and that you fear could be appropriated by the other party, perhaps don't share that specific detail. Give them a taster, let them know what your competitive advantage is or what your play is, but don't necessarily disclose the how you're going to do it and where you're going to do it, or precisely the what you'll be doing.
Thank you so much. I hope that clarifies some air and eases some nerves for some innovators. We do have time for just one more question that just came in, and then we can have our closing words. And the attendee says, I'm in the food business. Is it good to register my food branding to my two main products? And what would be the process there and implications, maybe for reflection?
Absolutely. Recipes actually are not typically patentable. So your recipes you'll keep secret, and you'll have to bind relative stakeholders, employees, to not disclose your recipes. That makes the branding even more important. So for food, there are various classes. You'll be looking at the classes that relate to your specific food product. As I said, you're looking at about 590 Rand official fees. It can be more expensive if you get an attorney to assist you. But for food products, it's essential, because either I'm ordering them online or I'm viewing them in a store on a shelf alongside other branded products. So in this particular business, I would spend a lot on my packaging. I would really prioritize protecting my brand, and even appointing someone to make sure I've got the right labeling specifics on my packaging that complies with the Consumer Protection Act's requirements. That would be my advice for someone in the food business.
Thank you so much, Christine. I think powerful thoughts and great value for the innovators out there. Do want to invite them to continue asking Q&A. It will be, this talk was visible on demand after the live session. And also a reminder that 4 p.m. There will be in the community board discussion, meet and greet about the IP primer, foundations of IP. Thank you so much, Christine, for your time. Please, everyone, enjoy the rest of your day.
Thank you. Thanks, everyone, for joining us.